Today is the third part of our series, and today we will be talking about interpretation of statutes. So you know what statutes are? They are mostly called as legislatures will, and whatever law you read are known as the acts and amendments, directives, orders, rules. Everything form a statute. It's not limited. कभी कोई limited नहीं है कि सिर्फ act को ही आप statute बोलोगे या जो order या सर्कुलर्स उसके बाद में निकले हैं और द जजमेंट्स हैं जो the interpreted judgments of the Supreme Court will not be treated as same. But the thing is कि statute हर वो चीज है जो legislature का will है तो वो statute है. अब उसका amendment उसमें जो interpretation का power है that has been given to courts. Okay, to interpret it correctly. We as lawyers have a duty to put forward our interpretation before the learned honorable court, and the court will take note of our pleadings and therefore will come to a final conclusion that as to why and under which manner this particular statute is required to be interpreted. Okay, so for doing so, it is important first to understand how many kinds of statutes are already are already present. And for doing so, I will be giving you certain examples. Okay, those examples includes So first for interpretation of statutes, you need to know about two very well-known figures. That's Lord Denning and Salmon. Salmon and Lord Denning have been very much, important in framing and making people understand the laws and the principles for interpretation of statutes. Lord Denning used to be the chief of the House of Rolls in London, and he was actually known as the People's Judge. His idea of interpretation of statutes and his idea of doing justice was a public favorable thing, and he always kept the interest of public at large on the at the forefront, and then decided a case. He never if you read Lord Denning, there are around 4 set of books of Lord Denning which contains due process of law, limitation, and this contempt, and then you have interpretations. So when you read Lord Denning, your understanding of how this entire law would have been evolved in London, because the thing is, हमारे पास जो law है, that is not an ancient Indian law. What we are right now are subject to, it was more or less the law of the Britishers, which was established, which was introduced to India. The IPC, CRPC, even your civil laws, everything was codified and then introduced to the Indian subcontinent. And when that was done, so and after independence also, what we did was we didn't changed it completely. What we did was we adopted it as it is, because we found that the law was somewhat suitable to the circumstances of our country. Doing so, what we had to do is, while doing so, it is very much important to understand. And Lord Denning was actually very much open about his interpretations of statutes and his feelings over what law should be, how justice should be rendered, and all those things. Okay, now coming to how many types of statutes are there, so that it is every kind of statute, you have to understand that each and every statute has to be interpreted in a different manner, whether it is your act, whether it is your explanation, whether it is your amendment, whether it is your rule. So or whether a declaration, or it is only a simple notification. So those acts, rules, notification, orders, circulars, they will be interpreted on the basis of the nature of those statutes and the purpose those statutes wants to achieve. आप किसी भी एक्ट को जब पढ़ोगे और उसका इंटरप्रिटेशन समझोगे, उसके लिए जरूरी है उस एक्ट के बैकग्राउंड के बारे में समझना, ये समझना कि उस एक्ट का जेनेसिस कहाँ से हो रहा है, उस स्टैट्यूट का जेनेसिस कहाँ से हो रहा है, वो किस तरीके का स्टैट्यूट है, उसके स्टैट्यूट के सब्जेक्ट्स क्या क्या हैं, उसके पीछे का रैशनल क्या था. एंड देयरफॉर after knowing all those things, you are being able to interpret a statute in a perfect manner. और जो रीजनिंग और रैशनल की जो साइंस है लॉ में, where you find what law should be and how law should be, it is completely given. For that we have to go through the entire study of jurisprudence of law. Okay, now when we come to nature of statutes, the statutes, it can be a codified statute, it can be a simple declaration, it can be a kind of a remedy given to a person, it can be an amendment to a already established statute, there can be a penal statute like penal laws we have, the statute which there will be kind of statute which will be enabling in nature, like for example which will enable a particular government, which will enable or give right to a particular office or a person to do something which which should have been done, and therefore the disabling we have a disabling statute also, which will prohibit someone to do something which should not be done. Okay. Then we have consolidation. Many of acts, rules, and notifications are lying here and there for a particular kind of, like for example, if we take there are several circulars for mining law also. Though we have a codified structure of mining law, but then there are numerous circulars relating to numerous mining minerals and everything. So we have to consolidate them. That's known as consolidation of statutes, where you try to ensure that each and every, like what we did in the Indian Constitution also, what we did was there were numerous features in different constitutions across the globe. We tried to consolidate it. There were numerous circulars, orders, rules available, in different parts or different statutes, but they do not form a single statute. So what we do is, if like for an example, I have certain provisions which are related to illegal mining, but their amendment is there, but they are being written into written somewhere else. So I will be trying to consolidate everything and then put forward while interpreting them. Okay. Now coming to, now when you know what kind of statutes are there, you have to understand that there are theories of interpretations also. Okay. When you interpret a subject, as I told you earlier also, for the purpose of interpretation, you first need to understand that why, how, and what of the entire legal regime. Why this law would have come into existence, how this came into existence, and what purpose it suffices. So when you know these three options, you are on a better footing to understand or interpret a law. For doing so, we will be starting with literal construction of the statute. Literal construction means, it is not necessary to, put every time look to a law through eyes of different theories. Like, okay, we have to, okay, now we know about a lot of interpretation theories. We will go and look about, we will apply the golden rule, we will apply the strict interpretation on each and every law. It is not there. At the first and prima facie view, if you are able to interpret a law on its very literal terms, आप कानून पढ़ रहे हो और आपको कानून समझ में आ रहा है within a specific plain meaning of it. It is also known as plain construction, plain meaning of law. तो जो लॉ आप पढ़ रहे हो उसको आप प्लेनली समझ पा रहे हो, you are able to understand that law if as it is written, that is known as, and then you are able to communicate that very law to the honorable court. That is known as literal construction. मतलब whatever it is written, you are considering it as it is. There is no ambiguity in it. So what you are doing is you are defining only the plain meaning of law. Going further, what you will be doing is then you have golden rule of interpretation, what we call as a reasonable interpretation rule also. That says that in case of any ambiguity, and if someone is not able to understand the meaning behind a statute, then or the court is finding, or the lawyer is finding difficult to get through the permanent the meaning, actual meaning behind the statute, the principle of reasonability will apply. Okay. What a lawyer should do is that he should read the act, and the most reasonable interpretation of a statute should be put forward. This is the simple rule of golden rule of interpretation, that whatever you interpret, it should not be unreasonable. The reasonableness, अब यार जब तक आप कोई for people who are not able to get through the language, have a language issue on this, reasonability का जो issue है, reasonability का जो principle है, वो आपको हर act पे, हर statute पे apply करना पड़ेगा. रीजन बिहाइंड आपको कोई एक्ट समझ नहीं आ रहा बिकॉज कि आप उसका प्लेन मीनिंग और जो लिटरल मीनिंग है वो समझ नहीं पा रहे हो, In that case, what will happen is that you have to understand what can be the reasonable meaning of that very act. उसको ऐसा अच्छा, for an example, मैंने contract act पढ़ा, उसमें लिखा था that a contract can only be there when there is an agreement between the parties. Okay, very plain and clear meaning that there has to be an agreement between the parties. Okay, how will it happen? How will it not happen? There is nothing to be decided. It is the plain meaning says that the agreement has to be between the parties. So you don't have to apply the golden rule, the rule of reasonableness or any such rule, because the plain meaning is very clear. But supposedly you come across a statute where the meaning is very much, the plain meaning of the statute is not clear, and it creates a kind of and you need to interpret that very word in a manner so that it can, you can reach the outcome which you want. So for reaching that very outcome, that very interpretation, you have to be very clear that the interpretation has to be reasonable. Going down, you have strict interpretation. The rule of strict interpretation can be applied on penal provisions as well as tax provisions. You have to understand that this entire economy runs on taxation. आप जीएसटी जो देते हो, आप जो इनकम टैक्स देते हो, आप और पेट्रोल के ऊपर वैट देते हो, ठीक है, ये सारी जो चीजें हैं, इनके अंदर जो स्टैट्यूट्स होते हैं, मोस्टली स्ट्रिक्ट इंटरप्रिटेशन को हम पीनल और टैक्स स्टैट्यूट्स में लेते हैं कि भैया जो इंटरप्रिटेशन है वो लिबरल नहीं हो सकता. यू कैन नॉट से कि अच्छा यहाँ पे आपको ये पे कर 3 times पेनल्टी है, तो आप ये नहीं कह सकते नो वी विल टेक अ लिबरल व्यू. नो, द पेनल्टी पार्ट, the penal provision where there is penalty on not following the rule, not following the law is there, of for an illegal act you have to be punished. In those matters the interpretation will be very much strict, especially in case of taxation where the recovery of that amount has to be paid in where you have not paid a certain amount to the government, where you have not paid the license fee, where you have, willingly have where willingly you have try to evade from taxes. In that cases the court will have to apply the strict interpretation on you, and the punishment and the penal provision shall be strictly applied. The interpretation will be very strict. There cannot be no liberal attitude. Then comes the harmonious construction. We had yesterday also talked about harmonious construction. What is harmonious construction? As the word harmonious summarize that there should be pleasantness. Okay, whenever there, and when does any kind of unpleasant thing occurs? When there's a contradiction, when there's a dispute. Mostly in case of statutes, कानून के अंदर mostly कहाँ problem आती है? When there is a contradiction between a central act or a state act, contradiction between an act or a rule, contradiction between the act and an amendment, the basic act and the amendment, contradiction हो एक्ट के अंदर और सर्कुलर्स के अंदर, ऑर्डर्स के अंदर. तो जहां पे कॉन्ट्राडिक्शन होता है वहां पे हार्मोनियस कंस्ट्रक्शन का रूल अप्लाई होता है. फॉर एन एग्जांपल, आप ऐसा कोई भी एक्ट लो जहां पे स्टेट और सेंटर एक्ट दोनों में, फॉर एन टेलीकॉम पॉलिसी का आप लेते हो, इंडिया की टेलीकॉम पॉलिसी, व्हेन इट कम्स टू द टेलीग्राफ एक्ट एंड देन इट्स इम्प्लीमेंटेशन इन various states, the telecoms were very much ready and eager to adopt what the Telegraph Act says, but the state devised of a different policy, different what you say, different orders. They made different rules for with respect to telecom policy, and different statutes came into picture, which were at some points was not in consonance with that of the Central Act, Indian Telegraph Act. So now, in such a manner, when the matter will go before court, what will happen is, the thing which will happen is that while constructing and while interpreting those acts and those rules of the Indian Telegraph Act vis-a-vis the present state policy, the Indian Telegraph Act will prevail, the national telecom policy will prevail, and if anything which is in contradiction to the state policy or to the central policy, then a way will be taken out so that it can firstly the prevailing part will be the state one, prevailing part will be the central policy, but still the court and the law and we as lawyers and officers of the court will assist the court in interpreting the very statute, very policy in a manner so that the basic structure of the central policy and the state policies remain intact, and they should not come into conflict, and there can be a third way out. जो हम mediation में mostly करते हैं, win-win situation will occur. Therefore, a harmonious construction where we can set aside the dispute, sever the disputable part, and then we can follow the entire policy. There is no need of quash the entire state policy, or order something which depletes the entire state policy. What we can do is we can look after the aspects which can be severed from it, and therefore we can construct in a harmonious manner. Then when you go further, you have certain Latin maxims also, like expressio unius est exclusio ulterius. When the expression, which means when the expression is clear, there cannot be no ulterior explanation to the same. That means जब आपका expressively, when you go with when you are reading a act and the express, and it is expressly clear about certain things, the explanations cannot mean anything else. You have seen that किसी भी act में जब आप एक act पढ़ते हो तो उसके नीचे illustrations होते हैं, examples होते हैं, then there are explanations, sometimes explanations also. तो जब आपका ऊपर का part बहुत expressly clear है, वो सब कुछ expressly clear कर रहा है, तो उसका जो है आप उसके explanation को दूसरे तरीके से नहीं पढ़ सकते हो. अगर मैं कह रहा हूँ राम is a boy और नीचे लिखा and then I am explaining a boy is someone who wears skirts, आप उसको ऐसे नहीं पढ़ सकते हो. You have to read it कि okay boy है तो boy की जो dresses है उसके accordingly ही उसको पढ़ा जाएगा. You cannot read it ulteriorly. Okay. Then you have adjudum generis. Adjudum generis is when you need to explain when generic words. देखो होता क्या है, जब भी लॉ पढ़ते हो तो उसमें जो टर्म्स डिफाइन होती है नेचुरली उनका वही मीनिंग होता है. फॉर एन एग्जांपल, शेल का मतलब शेल ही होगा, और का मतलब और ही होगा, एंड का मतलब एंड ही होगा, और शेल कैन का मतलब कैन ही होगा. बट फॉर एन एग्जांपल, you come across a situation where you have to read the act particularly, then at that point of time the word or and shall will change their meaning. Shall becomes will become shall. Reason behind is that while doing so, while interpreting a statute on the principle of adjudum generis, you have to understand that while doing so you cannot change the nature of the statute. Okay, the nature, the reason, the logic behind putting those words across has to be understood in a manner. Okay, for an example, normally or and end का है ना बहुत generic meaning होता है, और मतलब या and मतलब इसके साथ, but at some times you have to read and as or. Why? Because at that point of time in that statute, and as a generic word also represents the meaning of or, and vice versa. Going down, you have nocitor resources. We have discussed it yesterday also. A man, as it's a very important phrase which says a man is always known by the company it keeps. And so for the purpose of nocitor resources, we can say that a man is always, as a man is always known by the company it keeps, a word is also known by the company it keeps. So for a purpose of a word, you have to understand that particular word will also be, like for an example, I keep a word, a very good word, into a company of bad words, that word will also be treated as bad. And for the same example, if I am putting taxation law, okay, and there I am putting mortgages with provisions of levy of taxes and all those things. With, for example, I see mortgages and levy of taxes. For the purpose of mortgages and levy of taxes, that the word here, the taxes, part of taxes will include into a financial act. Why? Maybe it is a part of TP, but then also at this point we will be reading in the context of tax law. So you have to understand under which law the word is written, what should it specifically mean, keeping in mind कि आप statute कौन सा पढ़ रहे हो. When you are very much sure कि आप statute कौन सा पढ़ रहे हो, then it becomes very much clear to you what should be the interpretation of that very meaning. Okay, there are a lot of principles, case laws, and a lot of uh, clarifications, explanations, judgments, which are important for you to understand while reading the interpretation of statute. In the later part of our courses, when we will be starting our regular classes, at that point of time we will be dealing with each and every principle in a manner so that you can easily understand what the interpretation of statutes mean. And while still we don't do it, or while we are not able to continue our classes, what I would like to do ask you is that you guys read Lord Denning and Selman when it comes to interpretation of statutes and jurisprudence. क्योंकि आप एक बात को समझो, हमारे यहाँ जो लॉ है वो इंग्लिश लॉ, हमने हमारा जितना भी मेजर पार्ट ऑफ लॉ अडॉप्ट किया है वो वेस्टर्न कंट्रीज से किया है, इंग्लैंड से किया है. सो वी आर अ कॉमन लॉ, देयरफॉर वी आर नोन एज अ कॉमन लॉ कंट्री. व्हेन वी आर नोन एज अ कॉमन लॉ कंट्री, तो हमारे लॉ का जो बैकग्राउंड है वो भी आपको कॉमन लॉ में ही मिलेगा. Therefore, to understand our law in a better manner, you must ensure that whatever you read, except the Supreme Court judgments, your theory should be backed by the understandings of lords of the Queen's Court. Okay, because then and you should be able to go to the federal court and you Privy Council के जो judgments हैं, या जो आज भी ब्रिटेन में या लंदन में जिस तरीके से लॉ का इंटरप्रिटेशन होता है, उसको जब आप पढ़ोगे तो आपकी क्लैरिटी आएगी, क्योंकि फाइनली प्रिंसिपल उन्हीं का ही है जो हमने यहाँ पे अप्लाई किया है. तो क्योंकि वी आर लिविंग इन अ ग्लोबल वर्ल्ड, आज की डेट में सारे प्रिंसिपल्स कॉमनली अप्लाई होते हैं, बट स्टिल फॉर बेटर अंडरस्टैंडिंग वी नीड टू अंडरस्टैंड कि हमारा जेनेसिस वहां से है लॉ का. सो वी हैव टू अंडरस्टैंड लॉ फ्रॉम देयर पर्सपेक्टिव आल्सो, टू इंश्योर कि हमारे यहाँ पे लॉ भी इवॉल्व होता रहे. उस जेनेसिस को, जैसे ही आप उसके जेनेसिस को समझोगे कि हाँ इसका ये जेनेसिस था, ये इस कारण ये लॉ ब्रिटेन में आया, नाउ अप्लाई दैट जेनेसिस इन इंडिया. अब आप उसको केस पे अप्लाई करोगे और फिर उस लॉ का इंटरप्रिटेशन करोगे. सबसे पहले तो आप देखोगे कि क्या वो जेनेसिस जिसके कारण वो लॉ आया था वो आपके केस पे अप्लाई करता है. सेकेंडली, वंस वी आर श्योर कि हाँ ये अप्लाई नहीं करता, तो यू हैव टू गो थ्रू अ डिफरेंट पार्ट एंड कन्विंस द कोर्ट कि सर ये प्रिंसिपल यहाँ इसलिए एप्लीकेबल नहीं होता, बिकॉज द फाउंडिंग genesis, the basic why this law was brought into picture was this, and this is not my case. But supposedly वो वैसे ही है, then you have to interpret it accordingly कि अच्छा what is the differentiation between your case and the genesis. Therefore you, and that also happens while you interpreted the case laws also. जब सुप्रीम कोर्ट कोई लीडिंग लॉ आपको देता है, आप उसको भी अपने फेवर या अगेंस्ट में यूज करते हो, on that part also, while reading it, while interpreting that judgment of the Supreme Court, whether it is in your favor or not, you first go through the facts, the reason why. And it's very it's very good that the Indian judges, whether it's a lower judiciary, whether it's a high court or Supreme Court, gave a proper reasoning why they have came to a conclusion. So look for that reasoning in an act. जब आप उस in an case law, जब आप उस reasoning को समझोगे, तो आपको समझ में आएगा कि okay, this is the reason, this is the main rationale why this judgment came into light. Now apply it to your case and understand whether the same applies to you or not. So this is how interpretation works. We will be coming tomorrow with the basic principles of contract, जहाँ पे हम पूरा contract law को एक बार short में in a very capsule manner we will be trying to discuss it. So thank you. Aniket Vyas signing out.